Hello folks, my name is Doug Pinkham with Pinkham and Associates. We are a dedicated family law firm in Orange County. By now you're probably sick of hearing that. I say at the beginning of every video. That's okay. We only practice family law. That's all we do. And this particular video is important. It's a technical thing. It's a very simple form. It doesn't take much, but it does a very, very serious thing in the process, so pay close attention. It is the FL 165, excuse me, FL 165. It is the request to enter default. And I'm going to go line by line. So some of you can see this video or see the form on the video itself, and you're going to follow along with me by line. Some of you do not have the video on the screen, so I want you to click on the link below and get this video printed out and have it in front of you. So pause this video and print that thing out and have it in front of you while we do this video. Okay. Background information on this. So the request to enter default, here's what it's for. Let's say, for example, you filed a divorce, or you filed a legal separation, or you filed a paternity action. Whatever you filed in family court, you filed your initial case. Then you served the other party. When you serve the other party, they have 30 days to file their response to the court and serve you with it. So at the end of 30 days, if they have not filed their response, you can continue to move on with your case. It's like they buried their head in the sand, or they want to intentionally delay, or they just don't want to be involved, or whatever it means. You never know why somebody doesn't respond, file their response to the paperwork. But if you serve them properly and you give them 30 days after the filing of or after you served them, and you have filed your proof of service with the court, then after 30 days, you can take their default and move forward in the case alone. That's the purpose of that, is so that somebody can't delay it forever, and they can't say, you know, or whatever. They just don't want to be involved in the case. They don't want to go. They want to intentionally delay, whatever it is. So this is the request to enter default. Again, if it's gone 30 days after you've served the other party, you can file this with the court. It's very easy, 2 pages. It's just really a bunch of signatures. Okay, so let's go through this form line by line. The top of this form, it requires, just like every form, your name, address, telephone number. If you have a fax number, you can include it, but it's not required. If you have an email and you want to put it down here, you can, but it's not required. Then attorney for, if you're filling this paperwork out for yourself, you can put your name in there. Next line says Superior Court of California, County of. Put the county of, you know, Shasta, whatever county it is that you want to put, or whatever county it is that you're filing this in. Put that county name there. Then the next section down there is the street and mailing address and city, state and zip of the courthouse that you're filing this paperwork in. And then the next line is the branch name, so the name of the courthouse that you're filing it in. You can get that information, the address and the name of the courthouse, online. Very easy to find on Google. Okay, then the next line is the petitioner and the respondent. The petitioner is the same petitioner's name that was the petitioner from the original filing. It never changes. The respondent is the same respondent from the initial filing. It never changes. So put those names in there appropriately. Then the next line is asking for the case number. You're going to put the case number in that line. Make sure you put the case number in correctly so that this goes through. All right, so number 1, to the clerk, please enter the default of the respondent who has failed to respond to the petition. Okay? And again, that's a petition for divorce, that's a petition for legal separation, that's a petition for paternity, whatever kind of petition you filed. This will get a default for you so you can continue on in the case if they don't file their response within the 30-day time limit. Okay, number 2, a completed income and expense declaration, FL 150, or financial statement, a simplified form, FL 155, is attached. You can mark is attached or is not attached. I recommend that you mark attached and you fill out that form. I have a video that'll help you fill out the FL 150. It's a little bit of work, but do it, get it done, attach it to this form. It will alleviate the probability that this won't get filed and you won't get your default. Okay, then a completed property declaration, FL 160, or financial statement simplified, the FL 160 is attached or is not attached. Again, I would, if I were you in that position of filling it out yourself and filing your own paperwork, I would fill out the 160 and attach it. Make sure you do the 160 correctly. All right, sorry about that little glitch. No problem. So we're talking about the FL 160. I would attach it if I'm doing the paperwork. If I was doing the paperwork for myself and I'm not an attorney, I would just do the FL 160 and also attach that to this. It'll keep it simple. It'll make it more likely that this will not get rejected. 2A says there have been no changes since the previous filing. So if you had previously filed an FL 150 or 160 and there's no changes, you could just mark that box and not attach anything. But you don't have to mark that box. If you're attaching them, you don't have to mark that box. B says the issues subject to disposition by the court in this proceeding are subject to a written agreement. So what B means is you've already put together some form of a settlement agreement or a stipulated judgment, some kind of written agreement with the details of everything in your case, your custody, visitation, child support, spousal support, if it's a divorce, if it's a paternity action, just the stuff about the kids, custody, visitation, child support, whatever it is. If you've got a written agreement and you're going to submit that to the court, you can attach or you can mark B. Okay, C starts to get a little more technical. There are no issues of child, spousal, or partner support or attorney's fees and costs subject to determination by the court. What that means, what C means, is that you did not mark, or the other person did not mark, custody, visitation, child support, spousal support, attorney's fees in their petition. So if those were not marked, then the court doesn't have jurisdiction to make orders on them anyway. So you could mark C, and that alleviates that whole issue anyway. D, kind of technical also, the petition does not request money, property costs, or attorney's fees. Same kind of problem, same kind of issue. So you could mark C and D at the same time if that's the case. So if that's the case, mark D. E says there are no issues of division of community property. So if you had a marriage, but there was literally no property obtained. Let's say you were married for a month, and during that month you didn't earn any money, you didn't buy anything together, you didn't. There's no community property. In other words, property that was obtained with community monies, monies that were earned during the marriage or purchased during the marriage, which are presumed to be community property. If none of that's true, there's just no community property acquired during your marriage, you could mark E. If this is a request to enter a default against the other party in a paternity action, then you would mark F. This is an action to establish paternal relationship. Then you simply date where it says date. You're going to handwrite your name underneath that or type in your name underneath that. And you're going to sign it to the right of the black arrow where it says signature of petitioner. Okay, then down below, under 3, it says A says no mailing is required because service was completed by publication or posting, and the address of the respondent remains unknown. So this is very, very rare. But if in the beginning of your case you gave notice by posting at the courthouse or by publishing it in a newspaper, those are very rare. But if that's how notice was given, then you're going to mark A. If that wasn't how notice was given, if notice was actually given because somebody handed, personally served the other party, that's the only other way to do it, then you're going to mark B, and then you're going to put the address or last known address in the big box below. Then you're going to understand you're signing this under penalty of perjury. Understand right above the date it says, I declare under penalty of perjury under the laws of the state of California that the foregoing is true and correct. So make sure that when you date and sign this, you're putting in the right address above. Okay. And by the way, if you were to sign this and send this in with the wrong address, you're likely to get your default. But the other side could come back later and overturn your default in 2 seconds in front of a judge by showing that you gave the wrong address. So make sure you put the right address there. And anyway, okay. So, and you're swearing under penalty of perjury that you're doing that anyway. So then put the date in there. Underneath the date, you're going to sign or print you're going to print or type your name. And then off to the right, you're going to sign your name to the right of the black arrow. Now, this form has a couple other things on the back side. So go to page 2. Again, like all these forms on page 2 and 3 and 4, put the name of the case at the top. So it's, Joe Blow and John Doe or whoever is the party's names at the top, and then the case number. All right. So if you are asking the court to order the other party to pay your fees or costs, then this section's going to apply. If you're not asking for the other side to pay for your fees or costs, then just mark A, costs and disbursements are waived, and then sign on the bottom. If you are asking for the other side to pay for your fees, your filing fees, your clerk fees, which might be $435 or whatever the current fee is. Maybe you have a processor's fee of $65 to serve the other party. Maybe you paid that, $435 for the filing fee. And then maybe there's some other fee. You could explain it to the right where it says specify, and then whatever that cost is. But if you are asking for them to pay for your fees, then you would write those numbers in there. Then again, you would date it, handwrite or type your name underneath the date, and sign to the right. Then the last one's very important. It is a declaration. I'm going to read it. It's number 5, declaration of non-military status. The respondent, you're declaring under penalty of perjury that the respondent is not in the military service of the United States as defined in Section 511 et sec of the Service Members Civil Relief Act 50 U.S.C. 501 et sec. So what's that basically saying is you need to understand that service members have special rights in court. Serving them needs to be done a different way. They have different timing. When they're on deployment, they have certain rights. They have certain rights that a non-military member person would not have. So if they're not in the military, you can date, write your name, and sign this. If they are in the service, you cannot write. You can't date and sign this section. Okay. Then you're going to file it with the court. Again, you're going to need to attach that FL 150, the 160 if you're attaching those, declaration if there's any kind of declaration attached to this. But otherwise, this is the request to enter default. I hope this video has been helpful. Again, my name is Doug Pinkham with Pinkham & Associates. in Orange County, California. Thank you very much.